Hello and welcome to SEND North Yorkshire's Guide to Appeals, General Information. This presentation covers the information that you need to be aware of for any appeal against a local authority decision. After this, you can then look at the specific guidance for your case, for example, a refusal to carry out a needs assessment or to issue a plan. All the sides have a commentary, some more than others, but you can pause, rewind and replay as many times as you need to. There are various stages in the EHCP process where the local authority makes a decision, such as will they carry out a requested needs assessment, or do they agree with the parent's choice of education provider, or do they think a plan should be ceased. At each and every one of these stages, if you disagree with the decision made by the local authority, you have a right of appeal. The right of appeal is contained in Section 51 of the Children and Families Act 2014. Subsection 1 of Section 51 states, a child's parent or a young person may appeal to the first tier tribunal against the matter set out in subsection 2. Subsection 2 describes the different types of appeal. These are disagreeing with the LA decision to refuse to carry out a needs assessment, disagreeing with the LA decision to refuse to issue an education, health and care plan, disagreeing with the description of the child or young person's needs in Section B, disagreeing with the special educational provision specified in the plan in Section F, disagreeing with the school or other educational institution named in the plan, or if no school or other educational provision is being named in the plan at all, Section I. A refusal to carry out a reassessment of need, when requested. A refusal to amend or replace an EHCP following a review or reassessment. Disagreeing with the LA decision to cease a plan. The sections that cannot be appealed are Section A, which is the All About Me section, which contains the views and wishes and opinions of the child or young person and the parents, and also Section E, the outcomes. Sections C and G relate to health, and D and H relate to social care. The recommendation regulations extend the powers of the SEND Tribunal so that it may make non-binding recommendations in respect of certain types of health and social care needs, Sections C and D, and health and social care provision, Sections G and H, that are specified in EHC plans. This does not apply in appeals against the local authority decision not to conduct a needs assessment, but does apply to when a local authority decides not to carry out a reassessment. The statutory process in relation to an education, health and care plan being issued must take no more than 20 weeks. The complete process starts from the date at which a local authority receives and acknowledges a request from a parent or young person for a special educational needs assessment and ends on the date of a final plan being issued. Not all requests for a needs assessment will result in a final plan. As stated earlier, there are distinct stages in the process. At the end of each stage, the local authority will make a decision. If you disagree with their decision, you have the right of appeal. In addition, an education, health and care plan must be reviewed at least every 12 months. It can be sooner. This would be an early annual review. After any review, the LA must decide to maintain the plan as it is, amend the plan, or cease the plan. Whichever of these decisions they make, if you disagree with it, you have the right of appeal. If an EHCP is clearly out of date and is reliant on assessments that were carried out quite some time ago, or information that was supplied quite some time ago, or if the child or young person's needs have changed, then a reassessment can be requested. If the local authority refuses this request, you have the right of appeal. The following slides go into more detail about this statutory appeals process. An appeal concerning a child aged 0 to 16 years can be brought by a parent or parents, someone with parental responsibility, or someone who cares for a child, such as a foster carer. A young person aged over 16 and under 25 can bring their own appeal. For a young child, that person can appoint a representative to act on their behalf during the appeal process, including at the hearing if they wish to do so. They can also have an additional person, a parental supporter, to attend an appeal hearing to give them further support. For a young person, it should always be assumed that that young person has the mental capacity to make an appeal to the tribunal. An appeal made by a young person will often be with the support of an advocate. An advocate can be a parent, family member, or other individual, including someone who is paid to do so. A young person can also appoint a representative to act on their behalf during the appeal process, including at the hearing. If a young person cannot bring an appeal themselves, then the appeal can be made by an alternative person. This is often the case if the young person does not have the mental capacity to bring an appeal and/or to make decisions about that appeal. The alternative person will be acting in the best interests of the young person. This will be any deputy appointed by the Court of Protection, or if this has not happened, then usually a young person's parents. It could also be a family member or someone from the local authority's social care team. The tribunal will still want to know what the young person's views are on the issues in the appeal, but it is the views of the alternative person which they will consider in deciding the appeal. An alternative person can also appoint a representative during the appeal process, including at the hearing, if they wish to do so. An advocate is someone who knows the young person, who understands what they think about the issues in the appeal, and so can speak on the young person's behalf. They can be a parent, family member, friend, or a paid advocate. They are not someone who can give advice on the issues in the appeal. A representative is someone who will give advice on the issues in the appeal, also prepare the paperwork, and represent the person making an appeal to the tribunal. They can also be an advocate. The representative could be a volunteer from a charity, a paid representative, a solicitor, or a barrister. Most appeals to the tribunal are made without a representative. The tribunal will support both parties through the process of making an appeal to ensure that it is decided fairly and justly. On slide 2, we named all the local authority decisions that can be appealed by a parent, carer, or young person. On this slide, you can see the most frequent reasons for appeal and the ones that we at SEND North Yorkshire are most likely to be asked to support with. In previous slides, we have talked about the statutory process involved in the issuing of an education, health and care plan by a local authority. This slide summarises the process. The diagram illustrates the different stages and gives the deadlines by which local authorities must make decisions. Throughout this process, a local authority must apply the correct legal test. This legal test is in 2 parts. The first part is, does or may the child or young person have special educational needs? The second part is, may the child or young person need special educational provision as set out in an educational health and care plan. The process starts when a parent, carer or young person submits a request for an educational health and care needs assessment to the local authority, who in turn send an acknowledgement of the receipt of that request. It is the date on that acknowledgement that is day 1 of the process. After 6 weeks, the local authority must tell you whether or not they are going to be carrying out an assessment. This means they will have referred to part 1 of the legal test. Does or may the child or young person have special educational needs? If their decision is that the child or young person does not have special educational needs, they will issue a refusal to assess notice, and you have the right of appeal. If they decide that the child or young person does have special educational needs, the process will move on to the next stage. In this stage, the local authority is going to collect as much evidence as possible to help them to decide whether or not the child or young person does need special educational provision as set out in an education, health and care plan. Evidence will include educational psychology reports, updated reports from health professionals or social care professionals involved in the child or young person's case, and updated attainment and assessment information from the child or young person's educational provider. If at the end of 16 weeks the local authority decide that a plan is not necessary, they will issue a refusal to issue decision and you will have the right of appeal. If they decide that a plan is necessary, the process will move on to the next stage. In this stage, the local authority will send you a draft copy of the education, health and care plan that they are proposing. You have 15 calendar days to request any amendments and also to request a specific school. After 20 weeks, the local authority must complete the final draft of the EHC plan. It is this point where the plan becomes statutory and legally binding. If there is any element of the plan that you do not agree with, you have the right of appeal, and we'll go into this in a bit more detail in future slides. This plan must be reviewed at a minimum every 12 months. Before you go to appeal, you must consider mediation. At the moment in law, you have the choice of having a mediation meeting or just requesting the certificate. If you have new evidence, updated assessments, or you feel that the local authority has underestimated the special educational needs or the special educational provision required, and that having a conversation with them may benefit your case, then mediation may be for you. If you've had lots of discussions with the local authority and feel that another conversation is not going to make any difference, you can just ask for the mediation certificate. This will allow you to progress your appeal. We have information on mediation available to you. We have a slideshow similar to this one on that topic. We also have the 1-minute guide, how to complete the online form for college mediation, whom we're going to talk about briefly in a moment. We also have a mediation leaflet on our website at SEND North Yorkshire. Every local authority has a statutory duty to ensure that a mediation service is available for parents, carers and young people. Collis Mediation Limited is the company currently commissioned by North Yorkshire County Council. They are experts in mediation and their website has a lot of useful information on it about the process and how they can support you. Another really useful website belongs to IPSI, Independent Providers of Special Educational Advice. They have a lot of free downloadable resources, including useful information packs on making appeals. There's also the gov.uk website. This has a consultation on SEND mediation and the regulations relating to it. Whenever a local authority makes a decision during the statutory EHCP process, no matter what stage it is, they must send you a formal letter informing you of what their decision is. This letter tells you what their decision is. It should also give the reasons for that decision. It would also go on then to give you some advice and information about what to do if you don't agree with the decision. This letter is really important. You must keep it safe. That's because not only does it give you your right of appeal, but if you are going to go to mediation or go on to appeal, both the parties involved in those processes will need to see sight of the letter before they will continue. As you can see on the slide, there's a number of things it does offer you. It does say if you disagree with the decision that you can contact your SEN caseworker, and you can do this, but please be mindful that you only have 2 months from the date of the decision letter in which to lodge your appeal. This may sound like quite a reasonable amount of time, but when you're trying to contact somebody and then you have communications going backwards and forwards as you try to resolve things, that time can disappear very quickly. It gives you our details as well, and also how to ask for mediation or appeal the decision. This is the text on the letter where it's telling you what your statutory rights are. They let you know about college mediation, who we've just discussed previously, and it lets you know what the process is. It also gives you the time frame for appealing. As I've stated, if you're just going to go straight to appeal and you're just going to request a mediation certificate, then the deadline is 2 months of the date of the decision letter. If, however, you're going to go to mediation, and the deadline is 1 month of the date of that mediation certificate, or 2 months from the date of the letter, whichever is the longer time. This is to ensure you have as much time as possible in which to get together all the information you need in order to lodge your appeal. In order to lodge an appeal, you must complete the correct form. SEND 35 or SEND 35A are the forms that you will need. Please note that SEND 35A is only to be used when the local authority decision has been to refuse to carry out a needs assessment. For all other appeals, you need SEND 35. These forms are quite easy to get hold of. If you go onto the www.gov.uk website, you'll see that they have a search engine. If you put into that search engine Special Educational Needs and Disabilities Tribunal forms, it will take you to the page where you can find them. They're in a numerical list, so you may have to scroll down to find SEND 35 or SEND 35A. We have a 1-minute guide to completing the form on our website, which takes you through the process with screenshots on a step-by-step, easy-to-access format. Completing a form can be a daunting prospect for anyone, which is why we have developed our step-by-step online guide to the SEND 35 and 35A form. However, I feel it would be useful to just skip through the different pages now. Page 1 is information that can be useful for you as the appellant or the person who's bringing about the appeal. You just need to read through it. It tells you about people who can support you, tells you about the form and how to complete it. Page 2 is where you will start entering information. Who is the appeal about? Would be the child or young person. What you're appealing against is the decision that the local authority have made that you disagree with. Page 3, school details and provision details are fairly self-explanatory. Health or social care recommendations are in there because the SEND tribunals have the powers under SEND regulations to make non-binding recommendations for health or social care provision. Page 4 is your reasons for appeal. This is the specifics of what it is you're disagreeing with. So, do you disagree with the school named in section I because it says it's mainstream and you want a special school? Do you disagree with the actual provision in section F because it's not quantified or specified and therefore you don't know exactly what the person should be receiving? Those are just a couple of examples. Reasons for asking for a recommendation for health and or social care. Again, the specific explanations of why you feel that there should be health or social care recommendations. Page 6, local authority details and decision details, again, are quite self-explanatory. However, tribunal services may, if they feel the circumstances warrant it, accept a late appeal. These are quite specific circumstances and quite often the answer is no. However, if there has been a severe illness or injury or a bereavement or something like you've been forced to move house or you're a forces family and have had to relocate, you can put those details in and request that the tribunal service accept a late appeal, and they may do so. The majority of the rest of the pages on the SEND form are quite self-explanatory and straightforward to complete. On page 12, it asks for a list of documents and evidence. This includes those that you've put in page 11 on the checklist, and also any additional evidence that you want to send through to the tribunal service. There's a very specific way of listing these, but the example they give explains it really well. On page 13, you'll just find the disclaimer and the standards information. Then, when you get to that, you will have completed the form. Did you know that there are videos on YouTube that tell you how to complete a SEND 35 form? The slideshow shows the URL address, which you can copy down if you want to, but you can also find the videos by searching for Suffolk SENDIAS in the YouTube search box. So thank you to Suffolk SENDIAS for these and making them available for everybody to use. There's a couple of key facts that we think it's important for you to know at the moment about the appeals process. The first is that there's currently a long lead time from submitting an appeal and having it registered with the tribunal service and the actual hearing. It's 50 weeks, and yes, that means that it's almost a year. However, the tribunal service has been proactive in recruiting new judges, and we know that they're working hard to try and start making headway into this waiting time. Another thing they're trying to do is to prioritise children and young people who are actually out of education and therefore receiving none. If you, as a young person or your child, are out of education, we advise the following. Type appeal, then your child's name or your name as a young person, date of birth, and then out of education in the subject header of the email. Stress that your child or yourself as a young person is or are out of education in the body of the text in the email. And also ensure that you state on the form that your child or you as a young person is currently out of education. This may seem like a little bit of overkill, but it's really crucial that we get this message across to them, as those out of education are more vulnerable than those who are in it. Both the SEND 35 and SEND 35A forms have the contact details of His Majesty's Courts and Tribunal Service on them. This includes the email that you can send your form and evidence to electronically. What you do need to know, however, is their mailbox has a limited size. You may not be able to send all your evidence in one email. You may have to send multiple ones. Don't worry, it's not a problem. It happens all the time, and the tribunal service are used to it. We just have to make sure that they know how much information you're trying to send and whether they've received it all. A good way of doing this is by working out how many emails you're going to need to send. Once you've done this, you would put in the first one, say for example if it was 3 emails, after your child's name and date of birth and writing new appeal, you would put 1 of 3. For the next one, child's name, date of birth, new appeal, 2 of 3 in the subject heading. And for the final one, child's name, date of birth, new appeal, and 3 of 3. That way the tribunal service knows that they have received all the information that you were trying to send. When you've sent off your form, please make sure you keep a copy of it, as you may need it in the future. As I mentioned at the beginning, these slides contained general information and advice around appeals. We also have other slides on the specific types of appeals: refusal to assess, refusal to issue, contents appeal, that's section B and or section F, and a placement appeal, that's section I. Please note you can appeal contents and placement at the same time if you disagree with all of them. That would be a section B, F and I appeal. We're going to be adding to this list of specific types of appeal presentations soon. Please keep an eye out on our website for those. If you would like further information and advice from us, please do get in touch. You can see our phone number and our email address on the bottom of the slide. Another really useful way to get in touch with us is by completing the contact form in our Contact Us section on our website. This is because the form enables you to give us key details, which in turn allows us to tailor our advice and support to your specific needs. I hope you found the information today useful. Please let us know via our feedback form on our website. We really do appreciate any feedback that you can give us. Thank you for listening.